Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with writing special stipulations. As a broker, I want to tell you, don't do them. Do not write any special stipulations. There are times when you need to, and the first thing I will tell you is, if you are not a Maximum One agent, and you learn of a special stipulation from a class, from another broker, from a contract, before you use it in your own contract representing any clients or customers of your brokers, please make sure that your broker does approve of that prior to using. So that's the first thing. The second thing is, you really need to try to avoid writing any special stipulations on your own. In the GAR contract package, there is an entire library of special stipulations already written for you by attorneys. In the RE Forms contract library, there is another contract package. There is another entire library of special stipulations written for you by attorneys that cover all sorts of issues. That is already all-encompassing for what you need for your contract. The issue is, when you guys write your own special stipulations, they don't protect your clients and customers in the manner that you think they do. And that's an issue. Another issue is, sometimes you guys write them and they're extremely hard to understand what is going on or what the intent of that special stipulation is. So let me back up just a little bit and let you know what the contract, specifically what the GAR contract package says about you as an agent writing a special stipulation. And what it says in the GAR purchase and sale agreement under paragraph B10C, under the disclaimer paragraph, it does specifically state that, quote, if the broker has written any special stipulations herein, the party for whom such special stipulations were written, A, confirms that such special stipulation reflects the party's complete understanding as to the substance and form of that special stipulation, B, hereby adopts each special stipulation as the original work of the party, and C, hereby agrees to indemnify and hold the broker who prepared the special stipulation harmless from any and all claims, causes of actions, suits, and damages arising out of or relating to such special stipulation. So, in other words, your public people really need to understand what that special stipulation means when there is a stip written in a contract for them. Additionally, it is in Georgia, it is law. It is OCGA, Official Code Georgia Annotated 43-40-25.1. And this was passed, I believe, in 2015, where it does say that it shall be lawful. There was a question as to whether or not a real estate agent writing a special stipulation would be considered the unauthorized practice of law. And so it was passed, and it is not. It was declared in that code section of our laws. It shall be lawful for licensees to complete listing or sales contracts or leases whose form has been prepared by legal counsel, and such conduct shall not constitute the unauthorized practice of law. It goes on to say, in completing the purchase and sale agreement, it shall include a description of the property, method of payment, special stipulations, or addenda the offer requires, and such dates as may be necessary to determine whether the parties have acted timely in meeting their responsibilities under the lease, offer, or contract. So it was determined by our Georgia lawmakers that an agent writing a special stipulation in a contract is not the unauthorized practice of law. That is allowed for you as a real estate agent to do. But here's the problem. Again, another thing is, we know that in the course of events for a contract, the first level of enforceability, so to speak, is the pre-printed verbiage in the contract and the fill in the blanks for that. Then if an agent or a buyer and a seller choose to add an exhibit, anything in that exhibit, if it addresses something that was already pre-printed in the purchase and sale agreement, supersedes the information or the agreements in the exhibit, supersede anything that was already addressed in the purchase and sale agreement. If there is a special stipulation that also addresses something already addressed in the purchase and sale agreement or in an exhibit, then the special stipulation supersedes or takes precedence over the exhibit, which takes precedence over the purchase and sale agreement. If there's an amendment, then the amendment takes precedence over special stipulation, which takes precedence over an exhibit, which takes preference over the purchase and sale agreement. So you need to be really careful. Never, ever, ever write a special stipulation that covers an issue already addressed in the purchase and sale agreement or in an exhibit. For example, if the buyer and the seller, if the buyer is including a loan exhibit, a loan contingency exhibit as part of the contract, as part of the offer, and in the GAR, in the loan exhibits, there is also an appraisal contingency already written in that exhibit. That's all filled out with all the information. What has to happen? What happens if it doesn't appraise? Notices, time frames, termination rights, amendment rights, so forth and so on. Then what happens is you write a special stipulation that says property must appraise for sale price. You've just negated, potentially, that entire appraisal clause, appraisal contingency from the loan exhibit. Well, what happens if it doesn't appraise? I don't know. That's all you put is property must appraise for sale price. Are there termination rights? Is there a time frame? Do you have to send notice to the seller that it didn't appraise? If you terminate, do you get your earnest money back? Is it by default? So forth and so on. Again, an appraisal issue is already addressed in a loan contingency. So now we're seeing all of those crazy special stipulations about an appraisal gap. Again, what we're seeing is a special stipulation. So you'll have an appraisal contingency in the loan exhibit, and then you guys are writing an appraisal gap special stip that says buyer to pay $5,000 above appraisal price, period. So, okay, let's say you're under contract for $300,000. It appraises for $300,000. Does that now mean the buyer has to come to closing with $305,000? Let's say the special stipulation said, should property appraise lower than sale price, buyer to pay up to $5,000, not to exceed contract sale price. So let's say we're under contract for $300,000. Let's say the appraisal comes in at $290,000. So let's say the buyer is now obligated to pay $295,000. That doesn't mean the seller is obligated to come down to $295,000. You're still under contract for $300,000. So you still have a shortfall of $5,000. So now what? Does the buyer get to terminate? If the buyer terminates, are they going to be in default? What happens to the earnest money? Is there a right? Do you have to send notice to the parties? Within how much time after getting the appraisal do you have to send notice to the parties? You guys are leaving all of this stuff out. Here's another great one that we have. I'm being a little facetious. Here was one that said, hang on, let me read you this one. Oops, not there. Okay, here's one, and this one says, this is one where the seller was looking for another house to purchase. So the seller's in the middle of a domino deal. Both buyer and the seller agree to extend the contract closing date as the seller is diligently working to find another property for the seller to purchase. If the seller has not defined and contracted a property to purchase by such and such date, then the buyer and seller will review and discuss their options at that time to either move forward to close or with the possibility of terminating the purchase and sale agreement. What does that mean? They get to discuss it. Okay, what if they don't come to an agreement at that discussion? What if the buyer says, no, seller, I'm sorry you didn't find a house, but I want to buy this one. You got to go through with it. Does the seller get to terminate and not be in default? Does the buyer get to terminate and get their earnest money back? What happens to the earnest money? Is a party in default or not in default? It just says they agree to discuss it. That has no bearing on the contract and going through with the contract or earnest money, so forth and so on. So again, you guys leave so much information out. You have the best of intentions, which is great, but you leave so much information out and you end up not protecting your client or customer when that was your intent. So I have a checklist for you, courtesy of Seth Weissman. Seth Weissman has, closing attorney with Weissman Law, has a book called The Red Book. The newest edition is out, and there are a myriad of special stipulations to cover so many circumstances above and beyond the stips that you have availability to in the library in GAR. And I want to thank Seth again so much for sharing with me this list of special stipulations. Now let me find it, and I'm not going to go over the list of special stipulations, but it is a checklist of things to consider when writing a special stipulation. So okay, so here is a list of key questions. Again, courtesy of Seth Weissman. I'll link his information below, and I highly suggest you purchase the Red Book. Will help you with your contracts. It is great. If there are any brokers watching, you guys definitely want to get this, even agents. So here are some key questions to ask when drafting a special stipulation. Number one, who is going to do something or cause it to be done? Number two, what is going to be done? Number three, to whom will it be given? Number four, by when? Number five, where will it be done? Number six, how will it be done? 7, why is it going to be done? 8, is there proof that it has been done? 9, what happens if it's not done on time or not done at all? 10, would a stranger to the contract, that's code for a broker, a judge, an arbitrator, a GREC hearing committee, an ethics hearing committee, GAR, NAR arbitration panel, that's what stranger means. Would a stranger to the contract understand exactly what was intended in reading the special stipulation? And could the other party misinterpret, twist, or misconstrue the stipulation? And a good exercise is to pretend you are representing the other party for just a minute. So when you write a special stipulation, prepare that you're actually representing the other side and what are various ways that stipulation could be interpreted. Again, you want to indicate what it is, who's to do it, by when, how you can tell, notice if it's not done, and then consequences for it not being done by a certain time. So for example, with repairs, if you guys are negotiating for repairs, the easiest way to do it is handle it financially, either having the seller contribute more to the buyer's closing cost, reduce the sale price, or at closing have from the seller's proceeds, payment going to a vendor of the buyer's choice. Those are much preferred ways of handling repairs because inevitably a repair is never done the way a buyer would do it, or it doesn't get done at all. And when you guys negotiate for repairs, you never put in the consequences of what happens if the seller doesn't do them, or you put to the buyer's satisfaction. Well, what on earth does that mean? But generally speaking, you would want to put, let's just take repairs, for example. How can you tell if it's been done? By when are they supposed to be done? Do you want invoices? Do you want licensed, certified people doing the repairs? Do you want an inspector to come back? What are the consequences should the repairs not be done? Does the buyer get termination rights? If the buyer gets termination rights, are they going to get their earnest money back? Does the seller have what's the time frame within which the buyer has to notify the seller? What's the time frame within which the seller needs to complete the repairs? And again, this is just one example. But with the appraisal contingency, as I said, with the appraisal gap contingency, we have several. We've got actually 2 wonderful appraisal gap contingencies written for us by closing firms. For the appraisal gap contingency, if you write an appraisal gap contingency and it's still the amount the buyer is willing to bring on top of a low appraisal, but if that's still short of the sale price, well, what happens? Does your appraisal gap contingency negate the rest of the appraisal contingency on the exhibit? Is that still intact? Are there time frames for notice? Are there termination rights? Are there termination rights with no penalty? What happens to the earnest money? In all of your special stipulations, I'm going to add one thing to Seth's checklist. You need to add if there are termination rights and what happens to the earnest money. There are a lot of special stipulations where you'll, for example, and I've done another video on this, the right to request repairs exhibit. And if they're not agreed to, it does say that the buyer has the right to terminate, but it doesn't address the earnest money. Yeah, I can terminate, but I want to get my earnest money back. That really needs to be spelled out. So again, I want you guys to think really long and hard and consult with your broker, with an attorney, consult these other resources. Again, the library in the GAR contracts form, the library in the RE forms contract package, the Red Book. There are a number of places to get fully drafted special stipulations that will protect your clients or customers, which is what your intent is, and to make sure that it is readily understood on both sides of the purchase and sale agreement. If you are a maximum 1 agent, we have about 8 pages of special stipulations that cover a variety of issues, including making a contract subject to a buyer's receiving down payment assistance funds so that they can protect their earnest money should that not happen, and the appraisal gap contingencies, option money contingencies, all kinds of things. So if you're a maximum 1 agent, that list of special stipulations that have been authored for us by various affiliated closing attorneys is available to you in the reference section of Paperless Pipeline. If you have taken any of my contracts classes that I teach through the Georgia Real Estate Academy, you also get those special stipulations after you take, as a handout, after taking those contracts classes. So I invite everyone. Our classes are hosted by Maximum 1 companies. They are offered through the Georgia Real Estate Academy, and they are open to agents throughout all of Georgia, regardless of which broker holds your license. The virtual ones, well, they're all open to anyone throughout the whole state. We have had many virtual classes with many students attending from all over the entire state. And the ones that are hosted in the branches, again, we welcome any and all agents from all brokerages. I will link the online training calendar below. And again, regardless of your company, sign up for a CE class. It'll say if it's virtual or if it's in a branch. And we welcome everyone to attend any of our CE classes that we offer and host. Thank you guys so much for watching. Dame Sparks, broker of Maximum 1 Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.